Hey everybody, this is Damon Moore, and I am back in my hotel after a long day preparing to go to trial. I just wanted to take a moment to have a conversation with you about a really interesting story that's been kind of making the rounds. It's been reported that Spanish-Tunisian actress Hiba Abouk filed for divorce from Achraf Hakimi, a Moroccan professional football player who Fox News and some other folks are estimating is worth about $70 million. Media reports say Abouk requested half of the marital property. The story that's currently circulating is that Hakimi put his assets in his mother's name, and that because of his forward thinking, shall we say, his spouse was not able to claim any of the assets in the divorce. Many men, as you can imagine, rejoiced upon hearing the news. City boy memes popped up on social media, and praise for Hakimi's mother rang out in the streets. And in the time since that story started making rounds, another set of reports have come out saying that the original story was not true. Those who say that Hakimi's, or I should say those that say that claims that Hakimi outsmarted his wife are untrue, suggest that the original source reporting the story is somewhat suspect. Others claim that the majority of European countries, including ones in which the player lived, in those countries, marital property laws or marital property systems that are in place would not have allowed a result like the one that's being reported, a result in which the wife walks away with no property. I haven't practiced law in the counties, or in the countries in which Hakimi lived, so I'm not in a position to give an opinion on whether any news reports about him are right or wrong, accurate or inaccurate. But what I can discuss is how I think a case like this would play out in some states within the United States. So let's do that. In the US, you basically have two different types of marital property systems. One system is called community property, and the community property system is in place in a minority of states, maybe 9, 10, 11 states, a very small number. The other system is called, some people call it a common law system. I'm used to hearing of it as an equitable distribution system. And that system is in place in the majority of states. From what I've heard, it's 41 states, and it's also the system that's in place in DC. Under the under the common law system, or under the equitable distribution system, the court tries to divide the property in a way that the judge thinks is fair under the circumstances. The division does not have to be a 50-50 split, but it is often a 50-50 split or something that's very close to it. In some equitable distribution states, the state legislature might set out or provide a statutory list of factors that a court must consider in dividing the property. In other states, judges may come up with a list of factors. Some factors that I've seen when I've researched the issue are things like the earning capacity of each party, the future prospects of each party, the age and health of a party, the length of the marriage, the value or type of property that's involved, the conduct of the parties that is the cause of the divorce, or the conduct of the parties that are at issue in the divorce, I should say. The desirability of awarding the family home or the right to live in it for some time, particularly if one of the parties has children. the circumstances or the necessities of the parties, or the time and the manner, the acquisition of the property that's in dispute, the income producing capacity of the property, the value of the property at the time of the division. Those are all factors. When I think about this case with Hakimi and Abouk, one of the things that kind of pops into mind for me is that the length of the marriage was relatively short. If I remember correctly, I think they had been a couple for maybe approximately 5 years, and they've been married for approximately 3 years, something along those lines. So in a case like his, if that were in the United States, that would certainly be a factor. There could be some debate over what she has the ability to earn. They say she's an actress, if I remember correctly. So that might be a factor as well. Any number of things. And then you have this report, these allegations of behavior on his part that might be considered adultery, depending on what it is that he actually did, and the state that he's in. That kind of thing could be a factor. Keep in mind, though, that when we're talking about these equitable distribution states, I'm providing a very general description of the concept. So even in those states that consider themselves to be equitable distribution states, there could be some variation. So, for example, I'm licensed to practice in about 12 states in the United States. One of those states is Indiana. Indiana considers itself to be an equitable distribution state, but they do something they call the one pot theory. And under the one pot theory, all property is considered marital property. And when I say all property, I mean the property that was acquired after the marriage, but also the property that a person comes into the marriage with. The court in Indiana starts with the idea that that's all in one pot. It's all part of the marital estate, so to speak, and can be distributed in a way that the court thinks is fair. Now, another state that calls itself an equitable distribution state might not have the same kind of rigid requirements when it comes to saying that the property that someone acquired before marriage is part of that marital estate. And some equitable distribution states might allow you to elect to treat the property as community property rather than treating it as some other type of property. And I'll explain why that's important in a minute. But before I get into the community property system, I would say that regardless of what state you're in, if you're in the United States, you want to talk to a lawyer who's licensed to practice law in that specific state about your specific situation. This is just general information. It's very broad or very general in nature, and there could be exceptions. There could be things that might apply to you specifically, and you want to be able to take advantage of those, or you want to be aware of the fact that the other person might look to take advantage of those differences. So under the community property system, we generally look at a piece of property and we place it in one of three, I'm just going to say buckets or categories, one of three buckets, one of three categories. One is his separate property. The other is her separate property. If we're talking about a more traditional husband-wife, man-woman type of marriage. If we're talking about a same-sex marriage and someone was sitting in my office discussing this matter, then I wouldn't say his separate property, her separate property. I'd just say spouse A's separate property and spouse B's separate property. But for ease in discussion, for the moment, I'm going to say his separate property, her separate property, and community property. So a spouse's separate property in Texas, for example, another state where I'm licensed to practice, in that state, separate property might be property that's owned or claimed by a spouse before marriage, the property that's acquired by the spouse during marriage by gift, devise, or descent, and the recovery for personal injuries sustained by the spouse during the marriage, except any recovery for loss of earning capacity during marriage. If it's his separate property, then he does not have to split that property in a divorce. If it's her separate property, then she does not have to split that property in a divorce. If it's community property, then it gets split in a divorce in whatever way the judge thinks is just and right. The judge will start with the presumption that the property acquired during the marriage is property of both spouses. In the situation involving Mr. Hakimi, if he's in one of those equitable distribution states, then they're going to look at the property and they're just going to say it belongs to both people in most instances, and then they're going to do the split using the factors or taking into account the factors that I described earlier. If they're in a community property state, then they're going to determine whether the property is community property or separate property. And for him, the name of the game would be to try to make the argument that his property, that the property that he has, in particular the money that comes from his work as a professional athlete, that is somehow his separate property. Good luck with that. I'm interested to see how that plays out, or I would be interested to see how that plays out if that were to happen in the United States. One thing that I think you should also keep in mind, regardless of the type of state that you're dealing with here, is that states have certain rules that apply when a spouse is trying to hide assets. So it's not lawful for a spouse to hide assets in order to shield those assets from property distribution during a divorce. If you do this and your spouse has managed to find those hidden assets, then the judge may punish you with sanctions. And in some states, the judge might also award your spouse a percentage of the value of the hidden asset. Now, how does that relate to Mr. Hakimi's situation? Well, if it were in the United States, his spouse would make the argument that he is somehow engaged in what, in Texas, for example, they might call fraud on the marital estate, or fraud on the community, or waste of marital assets. There are a few tools in the box that you could use to make the argument that what he's done is inappropriate. There's some case law that says how you would evaluate that situation. And unless he was moving money and he made her aware of it, she's going to be able to make the argument that he was moving that money without her knowledge. And so it's unlikely that in the United States, Mr. Hakimi would be able to get away with hiding the assets so that he could get a more favorable property distribution in the event of a divorce. But if he's going to do it, then, or if he's going to be able to do it, then the reason in most instances is that he's going to, or he has found a way to make the argument that his property, or that property, was his own separate property. So if you like what you've heard, or you want to hear more about property distribution in general, then be sure to like and subscribe and comment. When I see comments, then I know that the topic is of interest to you as a viewer. Be sure to tell others about what it is that you're hearing from me, and be on the lookout. I look forward to providing more information for you. Take care.